City of Stevens Point Police and Fire Commission meeting, recorded, December 1st, 2020.
We'll call to order this special meeting of the Stevens Point Police and Fire Commission. Leanne, would you be kind enough to please call the roll for us, please?
Carlson?
Here.
Kirschling?
Here.
Moore?
Here.
Ostrowski?
Here.
Westcott?
I am present. In just a moment, I'm going to relinquish the floor to our major presenter, Attorney Gregg Gunta. Greg is the senior shareholder in the law firm of Gunta Law Offices located in Wauwatosa, Wisconsin. We have circulated Attorney Gunta's resume to all of you, but there are a couple of points that I think are worthy of highlighting. He is a specialist in municipal and employment liability and litigation matters. He has practiced law for over 40 years. He was an assistant city attorney for the city of Milwaukee for 8 years. He holds a Master of Science in Urban Affairs from the University of Wisconsin-Milwaukee, a good school. And his JD is from the Indiana University School of Law in Bloomington. Greg has achieved the AV preeminent rating from his peers and judges, which is the highest possible rating in both legal ability and ethical standards, reflecting the confidential opinions of the bar and the judiciary for over 20 years. And that rating most recently was from 2020. Greg has a success here with the city of Stevens Point. He first presented to the city council, the police and fire commission, in September of the year 2016 on the police and fire commission, the powers and authorities of the commission, on the origins of that authority and disciplinary issues that are related to it. The feedback on Greg's presentation was overwhelmingly positive. The alders, the city officials that I heard from, along with my colleagues on the Police and Fire Commission, thoroughly enjoyed it, learned from it. He is an expert in this area, and we are really quite privileged that we can welcome him here this afternoon. So Greg, with that said, I'm going to step aside and I'm going to turn the remainder of this Police and Fire Commission meeting over to you, sir. You have the floor, my friend.
Thank you. Can I just get kind of a roll call as to exactly who is on the line? Do we just have commissioners?
It is my understanding we do have some alders with us. Let me call on the alder liaison, or Tom. Can you share with Attorney Gunta what alders? I saw the comptroller with us. Could one of you just share with Greg who's here, please?
Yeah, I can go through it. We have Alder Kneebone, Alder Shore, Alder Jennings, Alder Zarazoa, Alder Fischler, and hang on. That's all I'm seeing at this point. If I miss somebody, we have the mayor here, we have some media, and then some community members.
Okay.
And we have the comptroller too, Corey Laddick, who I know you know too, sir.
And city attorney Beveridge.
All right. Hello, everybody. I got a call a little while ago from Gary to give a presentation, and I thought to myself, well, we must have had a huge turnover since the last presentation those 6 years ago. Over those 6 years, I can tell you, for those that were here before, there has not been an enormous amount of litigation, either at the courts of appeals of the state or at the Supreme Court, regarding the issue of police and fire commissions from the perspective of what we're going to be dealing with today, their origins of their authority and disciplinary issues. Now, for those that were here 6 years ago, I have to let you know that we're not going to be doing the hyper detailed presentation that we did last time, which dealt specifically with all of the types of liabilities that are potentially can be incurred by commissions. What we're going to deal with here today is really the origins of authority and disciplinary issues. A historical review of the laws of the state of Wisconsin is something where all of you who are on commission should go to first. I just got something that clicked on. Can you guys still hear me?
Yes, we can, Greg.
Okay. It looked like a great big green telephone. All right. So if you look at your outlines, you'll see that at the beginning, it's very interesting. And I found that the initial research into this that I did, it seems like eons ago when I was an assistant city attorney with the city of Milwaukee. And I was digging through the library at the Supreme Court in Madison, and I came up with some really interesting documents that gave me a background to the history of why we have police and fire commissions. And really, the state legislature in 1885, I'm going to go through the outline with you guys, in chapter 378 of the laws of 1885, created the police and fire commissions for Milwaukee. Milwaukee led really in a not so glorious way the creation of police and fire commissions. The city of Milwaukee back in the 1880s, especially in the late 1880s, allowed for political control over police and fire departments by the mayor. And that political control over the police departments and the fire departments resulted in a situation that became intolerable from the following perspective. There were local ordinances that were in effect which allowed for the mayors to appoint the chiefs of the police and fire departments. Now you can just picture this. New mayors would appoint their political allies. They had the police and fire departments. Then this resulted oftentimes in a resignation, not only of the current chief of police or chief of the fire department, but virtually all the police officers and all the firefighters. And until they got their shot again at the mayor's office, we would have a rotation in Milwaukee of policemen and firemen and police chiefs and mayors, and the stability was just not there at all. Continuity in law enforcement, continuity in fire services was not there. So the citizens ultimately responded at the ballot box, which is, I guess, what we oftentimes do, to this uncertainty. And in 1885, the legislature created the Milwaukee Board of Police and Fire Commissioners. Why? Well, the whole purpose, initial purpose, was to get the stability in the appointments of police chiefs, fire chiefs, and fire department officers. But the effect of it was really far more than that, because it stopped the city of Milwaukee's mayors from enforcing really draconian types of punishments and the like onto those that they did not like, who were either policemen or firemen or police chiefs and members of the fire department. And it stopped that process. It didn't give a disciplinary process at all at that point in time in 1885, but it did slow down this type of dictatorial administration of the police and fire departments. Then what happened? Well, the rest of the state takes a look at it and they go, wow, this has seemed to be working in that hellhole of the city of Milwaukee. And really, in some of the documentation that I found, some legislators from around the state called the city of Milwaukee back then the hellhole, and weren't afraid to say it in minutes of legislative meetings and committees. So in 1897, the rest of the state caught up with the city of Milwaukee, and the legislature passed the laws of 1897 under Chapter 247, and we got police and fire commissions in second and third class cities. Now, what are you guys? What class city are you? It's a test. Does anyone know what class city you are? I can tell you you're not a first class city because there's the city of Milwaukee. Some say Madison is as well, but it's primarily the city of Milwaukee. Do you know what class?
I'm gonna go with third class.
Okay. Anyone else?
Second.
Well, this is your, was there another statement that I just missed?
Yeah, that was me, Andrew Beveridge. We're a second class city.
All right, that's what I thought. All right, so being a second class city, the laws of 1897 apply to you, and they apply to you with their full force and effect, and you are a commission created under the laws of 1897. And it's rather something to be proud of. I don't know when your commission actually was first formed, but I imagine your commission historian, if there is one, usually self-appointed, can probably figure that out for you. The commissions back then were made up of 4 persons, only 4. No more than 2 of them could belong to the same political party. And, you know, this whole concept back then was we had 2 political parties, and those 2 political parties weren't going to give in to each other. Nothing's changed in our world. It was just as contentious back then as it is today. But if you can picture this, if you have 2 of each party, and that's all you have is 2 of each party, there were deadlocks that were forestalling the operations of the commissions. And that wasn't good either. That wasn't the intended result of the legislature. So currently, police and fire commissions consist of 5 persons, okay? 3 of whom constitute a forum. And today, only 3 of the same party. Now, what's going to happen, you know, someday if we have a real legitimate 4th party or 3rd party? Well, then the legislature is just going to have to take a look at it and see about expanding the makeups of commissions or making it more spattle. And in my history, there have been members of independent parties who have filed petitions to get on police and fire commission, saying that, in fact, they are a legitimate 3rd party in the state of Wisconsin. None of that has been successful so far because the legislature hasn't changed the statute. The outline that I've given you should be overwhelmingly helpful to you in following the statutory framework of police and fire commissions. Virtually everything that I present to you today and show you has got a citation to it, okay? So if you're on page 2 and you look at the 2nd paragraph, it says the mayor annually appoints 1 member for a 5-year commissioner term, and no more than 3 members can belong to the same political party. I give you the citation of the statute. So you can go look that up. It's right there. It's right in front of you. And the next section since it is also cited to statute, and that's that Wisconsin law provides cities with populations of over 4,000 shall have police and fire commissions, and cities under 4,000 create police and fire commissions by ordinance. Now, let me tell you a story that's true, and I'm not going to name the city. This just happened a week ago, actually. There is a commission in the state of Wisconsin that has a population of over 4,000 that has been putting itself up for election by the electorate since 1932. That is, no appointments by the mayor, no following of the statutory framework, no following of what Chapter 62 says should be followed as far as appointments. And they have, in fact, been being elected because of an opinion of an attorney general in I think it was 1932, it might have been 1938, but 1932 or 38, that said, really, the general statutes giving powers to municipalities to govern themselves overrules, really, the state statute creating police and fire commissions. And I read the opinion about a week and a half ago, and I looked at it and it looked like it was written by a 4-year-old. It was clearly done for pure political purposes and was just an absolute violation of law. And now that is changing in that city. It has to change. And think of this. Think of the effect of this. You've had disciplines. You've had chiefs that have been investigated. Chiefs that have and rank and file who have been disciplined and dismissed. All of that's voidable under the law because the commission is improperly made up and in violation of state statute. That's really a horror story. And everyone's crossing their fingers and just hoping that, that I wasn't the bearer of this horrible news to them, and that people who have been disciplined within the past few years aren't going to come back out of nowhere and say, hey, you were improperly made up, it's voidable under law, and I want to be reinstated. I don't know what the result of that would be. So we now have a section that I really want to emphasize today, and I'm going to make this a focal point of the presentation at the beginning and at the end. And that's the following. If you're on page 2, you see appointment of special representatives. Appointment of special representatives or observers to police and fire commissions, which are done either by common councils or by mayors, are in violation of the law. And it was argued that non-voting mayoral appointees who were actually a council person, I'll get into a lot of detail in this in a second, taint the entire process and void any action taken by the commission while under the shadow of the mayoral or council appointee or liaison. The name of the case, and then we're going to jump to page 20. And on page 20, there's 2 cases. And the case that we're going to be focusing on, and I'm going to give you a little bit more detail on, is the case of State ex rel. Heil versus Green Bay PFC. And it's a 2002 case. It was at the Court of Appeals. The decision was rendered by the Court of Appeals. It was going to the Supreme Court. It was at the Supreme Court. And when it became apparent that the appeal was going to be a loser, the commission in the city threw in the towel. And rightfully so, as they should have. Now, what happened in that particular situation is you had a situation where the mayor of the city of Green Bay was appointing someone from the council by the name of Thiessen. He was a really nice guy. I knew him for years. And he was allowed to fully participate in the operations of the Police and Fire Commission. He could do everything, sit in on confidential closed sessions, speak to finders of fact, consult with with commission people. The only thing he couldn't do was vote. Okay. Now, if you look at this from the perspective of what you know now so far today, you know that in 1897, as it applies to you, one of the whole purposes was to take the commission out of the political hands of the mayor and the council. And this is exactly what wasn't happening in the city of Green Bay with its Police and Fire Commission in 2002. Now, I'm going to get into this decision just a little bit more deeply because I think it's important, and I'll send you a copy of this, everyone. I think it's important to really know what the the Court of Appeals said in this regard, in this Heil case. The Fire and Police Commission was saying it really wasn't air at all to have this mayoral council member, this liaison there, because he really didn't do anything. He didn't vote. He didn't take any action as a commissioner, but he was there. And one of the quotes, which is so interesting from the court, was, while Thiesen's presence may not have infringed on the statutory authority of the 5 PFC members, it did infringe on Heil's right to due process, his right to be judged by an impartial board. So look where they're going, what they're saying. Court of Appeals is saying interference by non-commissioned, properly appointed commissioners, any type of interference, even presence, will violate, in situations where there is a disciplinary matter, the due process rights that we'll learn a little bit more about in a little bit of the person being charged before the commission. There's a couple more quotes. I'll give you it. The PFC, the court said the PFC is composed of an impartial body that operates independent of the city itself. And they cite cases, and I'm going to have all of this to you, all in one sheet, and it will all be sent to you. I was just too busy today to get it out, and I apologize. Other quotes are that member appointment is designed to prevent the board from operating as an agent of a city official or a police chief or a fire chief. In other words, commission people are absolutely supposed to be independent of all of those entities: fire chief, police chief, council, and mayor. One of the last things I will give you is part of their holding. The holding of the case stated that although Thiesen was appearing in the hearings and deliberations, but did not actually participate, had little or nothing to do with the violation of the intent of the statute, and was a clear violation of Officer Heil's due process. So mayors can't appoint anyone to come on and sit with the commission. It's really against the law. It was ironic, though, I do want to tell you, because Thiesen described himself as someone who was there to render input as to knowledge of issues that the council may not have, and that he was a resource in these deliberations. Well, the court threw that out the window and said, commissioners don't need you as a resource or anyone else other than their legal resource and their legal counsel. So the Heil case is very, 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 very straightforward, very clear in what it stands for. No one but commissioners, or if they do appoint a fact finder under the rules, have any right at all to invade the province of those 5 people. It's that simple. No.
Greg, can we ask a question yet?
Sure, you can.
We have a question that's been sent in to us here based on what you've just outlined. Could a mayor appoint a member of the Common Council as a voting member of the commission? In essence, can an alder also serve as a commissioner?
You know, that's come up repeatedly. And, you know, I think that I'm going to answer it the best way I can. Could that person, that mayor, appoint an alder as a commissioner? Probably. I find no real violation of the law that would involve. But let's stop and take a look at the intent of the law.
Right.
Chapter 60, that would be a clear, I have a little Scottish Terrier who's probably going to go nuts in a minute, so just ignore him. The intent of this law is clear. It's political hands-off. And political hands-off, can you just hold on for a second, you guys? I got
Sure, go ahead. Go ahead.
All right, that's enough.
Well, we all remember when the first police canine took over the commission meeting. So it was like, and who's going to mess with a canine for the police department, right? So we're somewhat sympathetic to that. Thank you all for spending some time here with us today. And Greg, I was just reminding the commissioners that the first time we were introduced to the first police canine, the dog literally took over our meeting too. So we have some background there.
Well, before I finish the answer, it's obvious if anyone's ever had Scottish Terriers, they have a mind of their own. They didn't care at all that I was on this conference call. So here we go. That would really seem to be a slap in the face of the intent of the law. And there's supposed to be this separation. There's supposed to be political hands-off. And if there isn't this separation of political hands-off, I'm willing to bet, now if we have other lawyers on here, they can throw in their 2 cents as well, but I'm willing to bet that if someone challenged that type of appointment, that there would be a fairly good chance that a court would find that it was not meeting with the letter of the law, with the intent of the law. And we just create new cases. It would be new case law. So that's a very interesting thing. Maybe if someone tries it, to do it, if someone is so inclined to throw politics into the commission operation, well, leave it up to the courts. That's what they're there for. I think that's the answer. At least that's the answer that I'd give. Any other questions so far, you guys? All right. Well, we have people listening on this this presentation that are going to fit into some of the categories I'm going to address right now. And I'm sure that there will be some questions from some of you. Let's take a look. We're on page 3, Statutory Authority and your Police and Fire Commission. Well, the statute have said that the management and control of the city's police and fire departments is established in a number of state statutes. And those state statutes all separately establish 4 separate individual bodies, boards, that have that real operation authority. And that's the mayor of the city, the police chief and fire chief, the common council, and the board of police and fire commissions. And that is a fact of law. The mayor, let's take a look at the mayor. And all of this, the mayor has multiple authorities, everyone, and we all know that. And I'm sure the mayor who's on this call probably is well aware of, has probably attended some of the league seminars or some of those. And all of you guys who are mayors, and I know you can smile a little bit because we have 2 of them here, that you probably got a pretty good education from the league at one point in time, unless they're not doing that anymore, as to exactly what your authorities and powers are. So 62098 A through D provides your authority. And if you're the mayor and you're the chief executive officer, you certainly are. The mayor shall take care that the city ordinances and state laws are observed, enforced, and that all city officers and employees discharge their duties. That's kind of that kind of catch-all phrase that's right at the end there. That's the one that people have latched onto as to expanding the authority of the mayor. And they've been successful in doing that. It is a rather wide open statement in the statute, except in 6213 sub 6s. Now, this is kind of an incredible, almost almost clear statement in the statutes as to what authority the mayor has over a 6213 sub 6 optional police fire commission, which is you. And if you look at 62098D of the statutes, when you get a little bit of time, you can, and we'll deal with the optional powers in a little bit, but let's now just look at it as it relates to the mayor. All these A, B, C all lay out the authority of the mayor. And then D says, except in cities that have adopted 6213(6) with stats, the mayor shall be the head of the fire and police departments. We know that, except in cities that have adopted the optional powers of 6213 sub 6. Okay. And that's something that I learned many years ago in the city of West Dallas, when at that particular time, that mayor was trying to really push orders onto the police and fire departments, executive orders. And that one phrase there stopped him in his tracks because he didn't have the authority, because they're a sub 6, an optional powers commission. So the legislature, by creating this optional powers subcategory of commissions, has created what they wanted to be a substitute, in a way, for the mayor having the executive control over the police and fire departments. Now, the question comes up, does that mean that if a mayor issues a lawful order to a police chief in a 6213 sub 6 municipality, that the chief doesn't have to obey the order? The answer is no. If it's a lawful order and it comes from the executive officer, it's still a lawful order of the executive officer. This except in 62098D really goes to the operations of the police and fire departments. Okay, and we'll see that in a little bit. So we have, I know that you're a 6213 sub 6. You must have had a referendum at one time, and that referendum must have passed, and you are in that particular category, which makes you fairly unique among not a whole lot of other municipalities in the state of Wisconsin. Doesn't mean it's bad. It could be a plus. All right, let's go down now, because there are members. We're going to go down to the Common Council, and those provisions of 62097A. The corporate authority of the city shall be vested in the mayor and the Common Council. You've got corporate authority, all of you council people, and the mayor are on the line. You have that corporate authority in a broad statement. But as your lawyers can tell you, when you have a specific statute or statutory scheme like 6213, which creates a box of authority around the operation of police and fire departments, and specifically police and fire commissions, that very specific box of statutory authority is what is applied, rather than these general broad statutes giving broad powers to common councils and to mayors. If that makes sense. If it doesn't make sense to you and you're thinking about it and it wakes you up at night, just give the city attorney a call and he'll explain that in further detail, or I can try to. The police chief also is covered by these statutes. And, you know, the police chiefs in non-6213, I'll just call them optional powers now, optional powers commissions, is actually the executive officer in charge of the police and fire departments. Now, I always tell mayors, don't ask for something that you don't want to get. I'll explain that to you. In federal civil rights law, you're the policymaker. For example, if the chief of police is is generally determined to be the policymaker of the police department, and you are sued under federal statutes, which I'm not going to get into now, but I've lived my life by them, and it is alleged that you have an unconstitutional custom policy or practice, you don't want to be the person operating that police department. You don't want to be the policymaker. So really smart mayors look at it and go, you know, that's what we got a police chief for. It doesn't mean if the police chief is messing up or doing something bad or illegal, or there's something that the mayor needs to have done immediately through an lawful order, it doesn't mean that that still doesn't stand as valid. But it does mean, really, mayors, keep your noses out of the operation of the police department unless you absolutely have to, because the last thing you want to do is be a defendant. I have to be careful here because I've got southeastern Wisconsin has several lawsuits that I'm defending now where the mayor has been sued, and he's been sued as a policymaker for what has been done. And you don't want to be there. You don't want to be there. If you've got tensions between the police chief, the fire chief, and the mayor, work them out. Don't exercise that authority where you may become a policymaker. Okay? And I give you a cite in here as to the fire chief. And it's really kind of interesting because 10M, 6213 10M, talks about subject to the approval of the Common Council, the fire chief or the police chief, it should say police chief in there, may establish rules requiring firefighters to obtain permission before leaving the city. That's an oldie. It's an old one that's been in there and it hasn't gone away, but it's still there. And I've really not seen a lot of councils that have stuck their nose into that or exercised authority in that area. But the Common Council is not to be sold short. And on my little outline here, I have the word money right under Common Council, right above powers, because the bottom line of the entire paragraph on page 4 under Common Council that begins 5 powers is management, control, finances, health, safety, welfare, appropriation, money, borrowing money, tax levying, appropriations, fines, etc. Common councils have that authority. It's for the purpose of what we're talking about here today, they got the money. They're the only ones that have the money. And really, as we all know, police and fire commissions, even optional powers commissions, don't have taxing authority. You just don't have it. So money for equipment, money for operations, all has to come through the council. And that's the way the law intended it to be. And it's kind of an interest. There are conflicts that arise, and I'll hit one or two of them in a minute before I deal with some side notes here on page 4. Believe it or not, if you look at the next entry, 6213-4E, the council of any city of the second, that's you, may provide that members of the police force shall be of both sexes. That's actually in the statute. So the Fire and Police Commission shall select each officer from the eligibility list, but the council has the authority to have police members that are, and fire members that are from both sexes. That's another one of those really antiquated statutes that really there isn't a whole lot of sense behind anymore. Let's go on though. Let's talk about this compensation. Compensation, this is going to awaken a lot of you. A lot of people don't know about this section. 6213 7 and 8 provides, the salaries of chiefs and subordinates shall be fixed by the council. Okay, let's just stop there because we don't have to go on to fourth class cities. Unless the council otherwise provides in cities of the fourth class for the apprehension of criminals, that's something separate, may be retained by the person. Just read along with me. Here we go. Such salaries, when so fixed, may be increased by the council, but not decreased by the council without a previous recommendation of the board, the Police and Fire Commission. The council may provide the salaries and shall increase with length of service. You can do all of that. You've got all that authority. You can raise the salaries, but you can't diminish them without board approval. Okay? It doesn't talk about the size of an agency or a department. It only talks about the salaries. So when you hear some people around the state say we're going to cut the salaries of our police departments and we're going to use the money elsewhere, not talking about reducing force, but they actually say cut the salaries of our police departments. It's a statement made out of ignorance, unless the commission has made that recommendation. Are there any questions? Okay. We've got the fire department and where the fire department gets its authority from, and that's also stated in the statute. And you've got rest days that are required by the statutes, and the Common Council is also directed by statute to provide certain rest days and hours of work for police officers and firefighters. I cite you the statutes. You can go look at those. You can learn what they say. The 14-year-old's trying to get in the room. I want to talk to you now about the authority of the Board of Police and Fire Commissions. And you might think, isn't that what he's been talking about? Well, no. I'm really going to get into the nitty-gritty of the four corners of the statute now. So we're on page 5. All right. The commission, having been created by the legislature, has only those powers which have been expressly conferred upon it, or that can be implied from the four corners of the statute under which it operates. But let's be honest and straightforward. It's a statutory created entity. It has no more authority than what the statute has created it to have. It's that simple. And there have been attempts over the years to stretch that authority and make that authority more than it really should be. That recently happened in a southeastern Wisconsin municipality, and it's just flat out, the authority's not there to stretch that power, to exercise that power outside of the statutory box that you're in. You can't do it. All right. The authority granted to the Police and Fire Commissions under Chapter 62 are really, really kind of interesting. At the bottom of page 5, and that's to appoint, suspend, or remove the chief of the police department and the fire department and the subordinates. But a number of years ago, in my practice of the law, the legislature came up with 6213 sub 5J. And Wisconsin statute states that the same 7 standards of just cause shall apply to disciplinary actions against police and fire chiefs as apply to rank and file members. So if you're going to discipline a police chief or a fire chief, you've got to follow strictly the parameters of 6213 sub 5 EM. If you don't, you've exceeded your authority. And only you have the authority under the statute to apply those 7 standards to the police chief, the fire chief, or any of the rank and file. Okay, you have the authority to appoint, make all appointments, approve all the appointments made by police chiefs and fire chiefs. You know, that kind of differs as to how it's done in a lot of different municipalities. Some chiefs submit a written a written request for approval to a commission. Others just submit a list of names with a hierarchy. It's done in a number of ways, and the statute really doesn't care how the commission effectuates the promotion of subordinates, as long as it's based upon a recommendation of the chief. Approve competitive exams, approve suitability of appointments of subordinates. You know, a lot of times in some of our municipalities, we have a lot of familial relationships existing on police and fire departments. And a lot of times promotions are attempted to be made. I won't say a lot of times, because it's nowhere near what it used to be. Promotions were attempted to be made of people who were not necessarily qualified, but had a close family tie to the chief. And there are cases that have come forward before our state courts, which have said, no, we're not, the commission didn't have to approve that type of appointment because the person wasn't qualified for that position. All right, and you can initiate charges against the chief of a department and any subordinate. The commission has that authority. So does anyone. Anyone can come forward as an aggrieved party and press charges against not only the chiefs, but against any subordinate. And that's allowed under the law. So, but what's interesting is, so can a commission. So a commissioner or a commission as an aggrieved party. Now that is a mess. That's a mess. Then you have to look at an outside authority coming in and handling as a form of a trustee a situation where you've got 2 or 3 commission members filing charges against someone that they're supposed to make a determination of discipline on. And sometimes you see my finger going to my head, people just don't think. Because anyone can make those charges and thereby not disqualify members of the commission. We're going to get to that, how that gets done in a minute. And then you can hear appeals of disciplinary actions initiated by the chief. All of that is in the authority line that you find on page 6, and you can all deal with that and read those statutes. And if you haven't, you should, because it's your authority level. Now we've got your optional powers, municipalities, and that's you guys. One of the primary things you can't do is you can't raise money. But then no commission can raise money. So you're no different than any other police and fire commission in that respect. But you can organize and supervise fire and police departments. You can prescribe rules and regulations for their control and management. You can contract and purchase all necessary apparatus, supplies for the use of those departments under your supervision, and exclusive of the erection and control of the police and fire stations and buildings. You can audit all bills, claims, and expenses of the fire and police departments before the same are paid by the city treasurer. So you can actually step in and look at, my goodness sakes, that's ridiculous. We're not going to pay that amount. Don't process this. And you can audit those bills before they go to the treasurer. So you actually are a very unique commission and have all of this, because if you really look at those 3 points, they're imparting enormous responsibility on you. And you're doing a whole lot more than other commissions that are not sub-6s or optional powers are. And good for you. I mean, it's not a good thing or a bad thing. It just means that you have more obligations and duties than others. But where you don't differ, even in the least bit from commissions that are not optional powers, is your disciplinary abilities against subordinates of police and fire departments. You're all the same. And let's just take a look at that. Police officers and firefighters may be suspended with pay by the Police and Fire Commission pending the charges filed against them. Now, don't suspend someone without pay. Don't do it unless the person's committed murder, and then they may be entitled to get reimbursed if you're sued for depriving them of their property right before there's been an adjudication through a disciplinary process. You have to be very careful of that. The rule of thumb is don't. No matter how much you want to, don't. No matter how bad you think the conduct was, don't. It's not worth it. You just tie yourself up in litigation later. Okay? I've already talked about who charges can be filed by. And then Police and Fire Commission bias is something that every lawyer that defends someone before a commission has tried to throw into the mix whenever they can. And it's generally a result of commissioners opening their mouths when they shouldn't open their mouths about how things are going to go in the disciplinary proceeding. You know, it's almost hard to believe after all these years that when you're appointed to this position, this enormously important position of being a commissioner, why would you go and comment to the press or anyone else about the adjudication of a disciplinary hearing of an employee or the future disciplinary hearing of the employee? I can't answer that question. That's so far beyond me. I just don't understand it. But it happens. And the word knucklehead has been used to describe it. That's the only reason anyone would do that. Now look at this, what it says. And this is right out of a very famous case among us who look at this law, and that's the Ritchie versus Nina case. It's on page 7. I'm going to read this because it's important. In the absence of showing that 4 members of a 5, it says man, because that's what the court said, 5-member board of police and fire commissioners did not exercise their judgment in good faith on the basis of evidence adduced at a second hearing, the reviewing court would presume that the members acted in accordance with the law and authority conferred upon them, and that they acted fairly, impartially, and in good faith, even though the 5th member of the board prejudged the case, and in that case opened up his big mouth when he shouldn't have, and made commentary on the case and his opinion of it. Now, that's fine. Okay, so you got 4 there that can still go forward under Ritchie. What if you've got 3 out of the 5? Or 4 out of the 5 who've telegraphed before they've heard the evidence their opinions on the findings? That's a tough one. That's a tough one. And one would say that that shouldn't go forward, or it should go forward, the hearing, just so that the officer, chief, or subordinate could appeal that to the court, to the circuit court. because otherwise you don't have a right to discipline it. Because Richie says 4 out of 5 good, honest, straightforward citizens who haven't spoken out to the press or otherwise are enough to go forward. But no one's ever said anything about 3 out of 5. So we don't know what the result would be. We really don't, because it's never really happened. So please, as commissioners, no matter how you're pushed, no matter how much you're prodded, no matter how much your phone rings at night from politicians, the press, keep your mouth shut in regard to the disciplinary matters you're dealing with, or you're going to lose authority over that disciplinary matter because you won't be able to put together a quorum of individuals who are not biased. Okay, that's a fact. That's another thing that still has to be litigated. That 3 out of 5, what do we do? I don't know. I think I know what the courts would say, but you can't go forward. Or if you do go forward, it's reversible or voidable. Any questions? I'm going to take a sip of coffee. All right, here we go. We're in the nitty gritty now. We're in just cause for discipline. And the just cause provisions of 62.135 EM are the envy of law enforcement officers across the country. There, it's the envy, period. I had the unique, I don't want to call it an honor, but I had the unique situation actually of trying the first just cause hearing on the discipline of a law enforcement officer, a sheriff's deputy, before the WERC hearing officer forever ago, just after this statute and its equivalent with sheriff's deputies came into effect. And I got to admit, I didn't know what the hell I was doing. I'd never heard of this before. I didn't know what are the 7 standards of just cause. And I had to learn them quickly. And there's something that the brilliance of this arbitrator, Carol Doherty, in Enterprise Wire, that's cited at the bottom. If you read articles about how she created and dealt with this, it was brilliant, because let's go through them and take a look at exactly what they say. So now if I'm a police chief or a fire chief and I want to discipline someone, I look at the rules, because remember, we're dealing with rule violations. That's what you deal with. I look at that the same way as a chief as you do as a commission. I have to go through the 7 standards of just cause before I refer something to you for formal charges. I have to do that. So do you. Here's what you have to do. Here's what the chief has to do. You have to look at whether the subordinate could reasonably be expected to have had knowledge of the probable consequences of the alleged conduct. And the particular types of circumstances that fall under sub A are almost infinite. You have to look very closely at the facts and circumstances, period. And then you have to make the determination. Did that person, should that person have reasonably known that their violation of that rule would have led to discipline? It's a little more, it's tougher, as you know, who've gone through this before, than it just seems. Whether the rule or order that the subordinate allegedly violated is reasonable. Holy mackerel. There we go. Reasonable. What does reasonable mean? Reasonable to whom? It has to be reasonable to the type of operation in which the rule or policy has been made. Police, Is it reasonable for the police officer to look at that type of rule? Let's create a mythical police officer. You have that universal police officer look at that rule or order that another individual allegedly violated, and would they see that as being reasonable as a police officer? That should be something that other police officers should follow and not violate. It's reasonable issue is really. Now, it's easy ones in situations where you have some egregious conduct, but where you got fine line conduct, such as a rule that says you should seek immediate medical attention for someone you have used deadly force on. That seems obvious, doesn't it? You should seek immediate medical attention to someone you have used deadly force on. Let's say, I'm going to give you a real case. Let's say you're a police officer, you're in a park at 2 o'clock in the morning in a parking lot. You walk up to a vehicle, you look in the vehicle, the person in the vehicle's got their head back, looks like they're just nodded off. All of a sudden they awake, they reach down and they pick up a gun and they point it at you. And you shoot them. And you don't know whether or not that person, it's through a window of a car, has been killed, has been injured, still has the gun in their hand, is just waiting for you to peek in again until they can blow your brains out. Well, there's a fudge there, isn't it? Is it reasonable? Wasn't it more reasonable for the officer to get control over the situation, ascertain the level of that they had to rise to possibly again to quell the problem, or should they have run off and called for an ambulance? Now, I'm not going to tell you what's right or wrong, but I'm just showing you that it's not as clear cut under a lot of circumstances as you would think. Some officers say, I get on the radio right away and I call. Others say, I'm not getting on the radio and calling and putting another officer or anyone else in jeopardy until I know that the situation has been stabilizing. Two separate opinions on one action. Is it a violation of a rule that says immediate medical attention or not? Well, it's a tough one. C, whether the chief, before filing the charges against the subordinate, made a reasonable effort to discover whether the subordinate did in fact violate a rule or order. That's another one that seems obvious, but it's not. What does the chief of police or fire department have to do in order to make a reasonable effort to discover whether in fact that person who may have been among 3 or 4 other officers violated the rule or order? Whether the effort described in sub C was fair and objective. Wow. Did the chief just go after one person in the group of officers? Did the chief go after one person with more vigor than others? Did you, as a commissioner, go after someone with more vigor than you went after another person in the same situation? Was your effort described in C fair and objective? E, whether the chief discovered substantial evidence that the subordinate violated the rule or order as described in the charge filed against the subordinate. Well, substantial evidence, that's an interesting series of words. What is substantial evidence? I mean, is it preponderance of the evidence, reasonable, clear? I mean, it isn't defined. Whether the chief, in applying the rule or order fairly and without discrimination to the subordinate. Oh boy, this is a tough one sometimes when you have a racial, an ethnic, a sexual, a sex-based situation. It really gets tough. So the easiest thing to do is just look at it with blinders on and forget about the race, color, creed, or national origin or sex of the person. And don't get caught up in that type of a cross-examination by a defense lawyer. Whether the proposed discipline reasonably relates to the seriousness of the alleged violation and to the subordinate's record of service with the department. Well, you know, you're the finders of fact. You're the people who hear the evidence, you commissioners. You're the ones that apply the 7 standards of just cause. You're the ones who make that decision. You're the ones who determine, based upon the record of service of the individual within the department, the seriousness of the offense, what you determine is going to be the discipline. And you're supposed to do that by looking at all of these other elements, A, B, C, D, E, and F, in making that determination. And that's your decision, period. Good, bad, or indifferent, it's your decision. Now, on the next page, I wish I could actually say on page 10 that I actually wrote this checklist of just cause, but I didn't. It was written by another lawyer, and it was, I don't believe she practices anymore, but it was very, very well done. And you know, you can go through this checklist, and you know, if you've got a lot of yeses or a lot of no's, you need to take a close look at the evidence and in your analysis of 6213, and I hope you find it helpful in your deliberations or your evaluations. And chiefs, I hope you find it helpful in making your determinations. All right, we're going into the appeal section now, and I want to know, are there any questions up to this point? Hearing none, I'm moving on. All right, commissioner's liability for failing to provide due process. You know, we talked a little bit about this in the situation of the Heil case. We talked a little bit about, you know, what rights does someone have? Does a chief or a patrol officer have when they're before you on a disciplinary proceeding? And they have the absolute rights under the 14th Amendment to the United States Constitution to due process. And they have these rights because they have a property interest in their continued employment and a liberty interest. Now, what the hell does that mean? Well, to non-lawyers, a property interest means I got a house, I've got a car, I've got a dog, although some dogs don't think they're property. I've got a cabin up north, I've got all this property. In fact, I got a big Boston bank account. I've got all that property. Well, that isn't what the law looks at as a property interest. And it's a Wisconsin case. It's Roth versus Board of Regents from way back, and it's Perry versus Snyderman, and it was really a United States Supreme Court case based upon a situation in the state of Wisconsin. And it developed this property interest concept. And property interest is this. It's your right to have a job, your right to make a salary, your right to earn a wage, your right to collect benefits. And this is a big deal, because if you have that right, no one can deprive you of procedural due process by making charges against you and not allowing you to litigate those charges. So procedural due process is something that every single individual, simply stated, in any action taken to discharge, demote, or suspend a police or firefighter for just cause, that person must be afforded due process or the action must fail on appeal. It's that simple. And remember, we're going to talk a little bit about the appeals that one can have as an employee on, for due process failures by going to the circuit court in two methods that we'll talk about shortly. But there's also things called federal civil rights law. And if you deprive someone of due process of law, which we'll get into a little bit more in a minute, you subject yourself, you subject your municipality, you subject your coffers of your city government to loss in a federal court as a result of an action brought against you under 42 USC section 1983. A lot of you should know what that is. And you subject yourself to have to paying attorney's fees if you lose because you didn't provide due process. And federal courts have jurisdiction over this. So you as a commission, if you mess up, if you let these third parties sit in, if you let other people influence you, if you do a denial of due process of law to this person who has a property interest, you are subjecting your municipality to financial loss. And that's a whole new session. I could go on for hours about. That's how I make my living is Section 1983 law. And you don't want to face the tail end of a case where you've denied someone due process and you have to pay all of the attorney's fees of the plaintiff's lawyer who represents them at $600 an hour, recognized in the state of Wisconsin as reasonable. So you have a really important job and you got to stand tough on it. You can't let anything enter into your box of statutory authority where you're providing due process. Okay? What is due process?
Greg,
Yes,
could I ask a question? As long as we're talking about liabilities,
yes,
I've
sir.
always been under the assumption that our actions as commissioners, as long as we're acting in good faith, we're immune from civil liability. Is that true?
No, you see, the good faith principle is really not applicable to federal law much anymore. It's an affirmative defense. But really now what we act under is we act under the following. Excuse me. Go away. We act under the following. You're entitled to qualified immunity possibly, which is a whole legal principle that you should read about. You're reading about it in the papers now because some federal court judges don't believe law enforcement officers should have qualified immunity. You're also entitled to that as a commissioner. If you have a unique right in the state of Wisconsin, you can be sued as a commissioner. You can be sued, you can be brought into federal court, and you can be found to have violated someone's procedural due process. But you're very lucky because in the state of Wisconsin, everybody have a pen, write this down. Section 895.46 of the Wisconsin statutes gives you indemnification for any actions, for any judgments taken against you where you are acting within the scope of your employment. Okay, so you're indemnified. And that really gives you guys, all of you, men, women, whoever's on the commission, it gives you the ability to say to those who are trying to mess with your deliberations, you're acting within the box, putting pressure on you. You can basically use an old Italian saying, put your hand under your chin and move it forward because you're protected for your actions. You're indemnified for your actions. And any losses sustained or judgments taken against you, if something happens to go wrong, and they do go wrong, that is covered by either a self-insured retention level of your municipality, and that's why you have CIVMIC, because the Cities and Villages Mutual Insurance Company covers it up to layers and then layers upon layers. It goes over it. Hope that answered your question.
It did. Thank you.
Sure. All right, let's take a look. What is an individual entitled to? Notice of the charges. You guys know all about that. I'm sure your secretary of your commission made sure that notice of charges go out whenever anyone is disciplined. And then the individual is entitled to a hearing for the purpose of responding to the charges. There, and you've got your time restraints that are covered under the statute. You know what those are. You have to convene within X period of time, and you have to have the hearing within another X period of time. But we all know that you can adjourn and move forward just to give yourself time enough to handle the matter properly. The individual is entitled to representation. The individual is entitled to confront and cross-examine the accusers. And that's where it gets interesting. That's really, you know, as a lawyer, that's where it's a lot of, well, that's what we do. That's why we do it, to cross-examine someone, to cross-examine the chief on the 7 standards. I've seen masterful work by lawyers who take apart the charging party, just take them apart on the 7 standards. You know, we have something going on down here in the southeastern part of Wisconsin where we have a couple of lawyers who like to go after police officers before commissions, and they like to do it, although I wouldn't have them represent my dog in a first bite case. They like to make all these allegations against police officers, against police chiefs, to stir up and foment people from getting along with each other. And I find that once you get before a commission and you get the opportunity to put these people under cross-examination, like I get a chance to do in federal civil rights cases, usually you can get right to the bottom of what really happened, and the charges are being bogus or the charges being sustainable. But that cross-examination element is something that I ask you, Mr. Chairman, under the advice of your attorney. You know, the rules on evidence before you are kind of flexible. You know, it's not like you're in a federal court. You use your judgment to allow in rather than exclude, because there's a lot of appealable issues when you exclude stuff where there isn't if you let it in and allow cross-examination on it. But that's up to you and the circumstances. But you really should listen to your lawyer on those evidentiary issues very closely. Okay? All right, let's see what we can go to here. Now, once you've made a decision on a discipline and you have made the decision that this is what it's going to be, that individual whose decision was you decided on has 2 avenues of appeal. They have the statutory avenue of appeal, and they have the avenue of appeal of what's called certiorari. So 6213 sub 5I is the Wisconsin statute that allows for appeals from commissions. And you know, this should give a hint to people who don't know this area of the law, really about what the appeal rights are of people and why you really don't need to, until the whole appeal process is over, criticize, attack judgments, because the process isn't over until it goes through the Court of Appeals. And why does one ever want to prejudice a judge who's going to be making a decision? Maybe it's just because I'm a lawyer. I expect the process to play itself out. But the times are changing, and a lot of times that process isn't allowed to play itself out without people making comments. But I'm a firm believer in the rights of individuals. And I don't care if you've disciplined someone or not disciplined some, or by termination, or if it's been a 6-day suspension and they appeal it, they have rights under the law and under the United States Constitution, which still means something. And they have that right to appeal. And here's what they have the right to do. They can go to the court, they can go to the circuit court, and here's what the circuit court gets to look at. upon the evidence, is there just cause to describe, as described in paragraph 6213 sub 5EM, to sustain the charges against the accused? Okay? Were the seven standards met, 7 standards of just cause met in making the just cause determination? And there's a specific law in the state of Wisconsin that states that based on available evidence, was the action taken by the commission reasonable? Okay, was it reasonable? Now, the person who's lost their job, they're expecting to get a fair hearing or review on appeal to the judge. And it really doesn't help for commissioners, council people, anyone else coming in and making commentary and judgments before that final decision. Because it's just negating the appeals process that the law gives you as a citizen if you're a public employee. It's that simple. Now, a circuit court is also authorized to initiate a de novo review of the commission's just cause determination. The court begins, what is that? What does that all mean? The court begins its own review of the matter without particular regard for what may have previously transpired or the decision made by the commission. They can look at it de novo, anew. And for goodness sakes, why would anyone want to interject themselves into that process from continuing if a court's going to look at it? Why does that anyone want to not allow that process to play out fairly? That's just wrong, in my opinion. But then I'm just a lawyer. Okay? Under the standard of judicial review, the circuit court reviewing the matter makes a separate independent determination based upon all the available evidence. And they look at it with that particularity. Now, that is the law. And I could go on and on and on and tell you more and more and more, but you can read it yourself right here in front of you on to page 13 as to what a court may order. Now, what can the court order? We'll jump right to that. The court may direct the commission to consider and impose a different penalty. Now, that means that what you've done is not over. So you got to really hold tight. And they can order a different penalty. One that may be less or more severe. And there have been more severes. You know, there have been police officers who have gone through this appeal process, who've gotten extensive suspensions, who go to the district court, the circuit court, excuse me, and end up getting fired. And go, oh my God, why did I do this? What a mistake. All right, so that's essentially that statutory appeal. A writ of certiorari, that's something different. And that means under certiorari review, the scope of the court's review is limited to a determination of whether the Police and Fire Commission acted within its jurisdiction. Did you act within that box we talked about? And whether the commission acted under a correct view of the law. What's the correct view of the law? 6213 sub 5EM, the 7 standards of just cause. All right. Now, you can read about violation of the open meetings law. It's really kind of interesting because I've only seen this once in 40 years, but it's rather unique. Someone has a commission hearing, the commission violates the open meetings law, and the officer files a complaint with the district attorney's office, and a circuit court has the authority to penalize the commission found in violation of the open meetings law by voiding the action that they took. If this occurs, a commission could face the prospect of having to conduct a whole new hearing because it's void. Got to be careful on those. Okay? Now, any questions? All right, we've got case law. Now, I'm not going to spend, you can all read, and I'm trying to limit my time. I'm just going to tell you that the cases that I've provided you with that begin at page 16 and go to page 20, I have a very brilliant young lawyer in my office who looked and updated, and these are still really the primary cases in the area. We've already dealt with Heil. Does anyone have any questions about Heil? Good. Read it. Read it. Honestly. Now, I'm going to skip over Alexander versus the city of Milwaukee, but except for the following. You know, as a commission, if you've got a policymaker, a chief, who's making policy, and that policy is race-based, you'd be surprised if you read this case which way the court went on the race-based allegations as to who made the claims that they were discriminated against on the basis of race. So I'm not going to get into that, but you can read it, and you can see that if you see this happening and you see promotions being brought into you or disciplines being brought into you that are race-based, you got to put your foot down. You got to stop it. You can't go through it. You can't do this promotion. You can't do this suspension because you make yourself liable under Title VII of the United States Code. And read the case. It's very interesting. It's really an interesting case that you'll enjoy. There's this nasty little thing in there the lawyers can tell you about called punitive damages that can be sustained by having race-based promotions that you allow to go through you and happen. All right? And Tinsdale. It's really funny when you know the people who participated. This is a very interesting case because Officer M. Tinsdale was promoted to the position of sergeant upon the completion of a one-year period by Chief Michael Younglove. And you really have to know the history of this whole city and what went on there with Younglove and all of this other stuff. But he promoted a guy to sergeant and gave him a one-year probationary period. And that one-year probationary period had exhausted. So the next chief comes in, actually he's a very good friend of mine, and he sends a memorandum to M. Tinsdale and says, you know, I'm sorry, but I don't believe that you should have gone through the process and made it through the probationary process. So you're going back to patrol officer. This was all very political, what was going on. Just the kind of stuff that commissions shouldn't allow were created that wouldn't happen. And what happened? The bottom line was, if you have a specific probationary period and it passes, you cannot retroactively go in and take away that promotion. You can't take away that increase in salary. All right. What are suspension days? You know, when you give a suspension day, Balzerac versus, he was a character, versus the Board of Police and Fire Commissioners says it's working days. You give a 30-day suspension, it's 30 working days. It's not 30 calendar days. In the city of Madison versus the Wisconsin Department of Workforce Development, you can read that case, but basically that says that a disciplinary termination that is discriminatory under the Wisconsin Fair Employment Act has to be brought up during the disciplinary hearing before the commission under 62/13 of 5 EM, because what is one of the standards to be reviewed? The standards of just cause. It's whether or not the action was discriminatory, right? So That's where you bring up, you did this to me because I'm Italian. You did this to me because I'm black. You did this to me because I'm Jewish. Okay, that discriminatory action has to be brought up before the commission. Because of the four corners of the box on that issue being embedded into the 7 standards. Well, there's a hitch here. What about the Equal Employment Opportunity Commission of the federal government? I don't see it's been litigated. I don't see that a matter has gone before the EEOC. The state of Wisconsin, the Diller and its discriminatory subcommittee, sub-bodies, and the EEOC have an agreement. They share complaints that come in. And you never really know if the EEOC is going to take the complaint or the state is going to take the complaint. But what if the EEOC, the federal government, took the complaint? Would they be bound by discriminatory conduct being analyzed under 6213 sub 5 EM as the state was? I don't know the answer to that. It's never been litigated. Okay. Now, the City of Madison versus WRC case is an interesting case. Some of these cases are really very specific to the City of Madison, but it talks about a probationary promotion and what the rights of the chief are. And here's the 2 issues. Whether a firefighter who is promoted on a probationary basis but is returned to his former rank for failing to successfully complete probation for a non-disciplinary, and this is key, a non-disciplinary reason, is entitled to a just cause protections of 6213 sub 5 EM. That was the first question. It's a good question. Whether the police and fire police chief's decision not to recommend successful completion of the probationary period for a promotion of a tenured firefighter to a higher position was subject to arbitration. And the court held that an arbitrator may not substitute their judgment for the fire chief's determination. Why? You should all know the answer to this. Because it wasn't a disciplinary matter. And the disciplinary matter, not being a disciplinary matter, the chief has the authority to say, you didn't cut it, you didn't make it. Unless, of course, it was done for a discriminatory reason, and that wasn't the case here. And we only have a couple more, almost there. There's another very particular case about when arbitrators versus the PFC come into play. And I don't think you've ever run into that situation where your municipality has given away the rights or the police officers have given, or firefighters have given away their right to the commission, hearing their disciplinary matters to an arbitrator. That hasn't happened, I don't believe so. And then there's Conway. And, Conway is a very good case because it allows you as a commission, so a commission who isn't there full time, and commission there and isn't pumping every day on commission business, to hire a hearing examiner to go through all of the evidence and to make an analysis for you and to give you a comprehensive report and an evaluation of witness credibility. It's very interesting. This last sentence on page 19, the hearing examiner is charged with the responsibility to hear the case, prepare a comprehensive report, including an evaluation of witness credibility and demeanor for review by you, and including the recommendations of the hearing examiner, including the disposition of charges. But the bottom line of all that is, that's wonderful, it's great, it saves you a lot of time, but it's still your decision. You still have to review all of that information. You can't just say, Attorney Johnson gave us this, look at what a wonderful job he did, and not look at it and rubber stamp it. that's going to come into play. So, but hearing examiners really are not bad ideas. They give lawyers a little work. It's a joke. And then they allow you to really look at everything once it's come into a record, which is helpful. Well, you know, demotion back to a former position, like a police patrol officer from sergeant during a probationary period. Here's what the court said in Kraus versus City of Waukesha. Boy, this was a nasty one. The court also concluded that an officer who was promoted on a probationary basis but is returned during the probationary period to his or her prior rank, non-disciplinary reasons, does not possess a constitutionally protected property interest in the higher rank that would require an alternative type of due process other than that provided by the commission. It's always a question of, is it non-disciplinary or disciplinary? Non-disciplinary, promotional promotions that aren't interfered with because of discriminatory intent are usually left within the purview of the appointing authority, the chief. And then you've got higher. And there we are. Now, with that, I want to tell you I've kept within my time limit, almost. But it's a lot of information, and I know a lot of you, this is the first time you've heard this, not the commissioners, but it's the first time a lot of you have heard this stuff, and you shouldn't stop with me. You should read. Go get every one of those cases I cite, go get those statutes and read them. And read the cases that are contained within the annotations. Don't just go by what you think you're reading and understanding. Go read the cases that are based upon the statutory sections. And I know it's going to take some reading, but you know, it's better than reading a novel sometimes. All right, that's all I have to tell you. I hope I've answered some of your questions or provided you some information that you haven't had in your minds before. And I'll entertain a few questions. And I see there's chat going on, whatever the chat is. I don't even know how to hit that button, but I'd be happy to answer some of your questions if you have them now. Going once, going twice, going 3 times. Okay, well, I hope you all work through. Yes, sir. I hear a mouth, I see a mouth. Okay.
Yeah.
Brian, you got to turn on your, there you go.
I think Alderman Shore had a question. I saw him waving his hand there. Did you have one, Alderman Shore?
Well, I do, but if you want to go first, that's fine.
No, I just wanted to
thank
stop
you.
it because he was going, gone.
Yeah, thanks. Thanks for the presentation. It is very informative. Obviously, we alders are listening, you know, from a particular vantage point. You know, message received, to be sure, about keeping politics out and all the problems that go with that, all the history. You know, so there are, you know, there's plenty of statute and separation of powers and history and process that says we should just stay out. And I get that. And I think a lot of that was at some level understood all the way through, because it's not like a lot of comment was made. A lot of the discussion is taking place kind of post fact, right? But with all the problems there are with, you know, whether it's favoritism, patronage, or I grew up in New York City, you know, we were taught about patronage and, you know, and how all that worked in the 19th century. But I feel like there's also unintended consequences and another consideration, and we haven't talked about that as much, right? And that's the piece that's about the special public trust in a police chief. And, you know, politics is a dirty word, but politics is also kind of at the most basic level, just, you know, communities dealing with controversies and dealing with difficult situations, and, you know, and having public discussions. And I'm just left with appreciating everything that you say about protection of rights and due process. As the time, you know, as time goes by and things play, you know, and trust the process and let it play out. But what about the problem of that special trust and public trust and responsibility, and what, you know, that period of time in limbo means for the community's level of trust and confidence? Because I think, you know, to the extent that we're kind of speaking up and expressing concerns, that's where it's coming from.
I think you have an absolute right to be concerned about public trust and public confidence. You know, it's an interesting, I'll try to answer a little bit of what you said. I don't disagree with the thing you said. I think it's all very accurate. But it's called majority rule and minority rights. And until what I'm looking at right now, until a process has been completed, it's very difficult. I'm not talking about your city or your commission or your council. I'm talking in general that the personal rights of these employees need to be protected at the highest level until they've exhausted the appeal process. Otherwise, things get said and things get done that are very damaging to these individuals, their families, and to the credibility of the process. Now, do you as a council person have a right to comment on the behavior of a police chief or the behavior of a police officer that has been disciplined? And that process is over? Certainly. Common councils in the state of Wisconsin have, you know, First Amendment rights as well. I mean, you're allowed to do that. It's when the actions of a council, and I'm not talking about you now, I'm talking about another couple that I'm thinking of very clearly, who interject themselves into the process where hearings are done or where determinations on discipline are being made, and they make statements and they attack people and they criticize people who are trying to do their jobs as commissioners. That's not right. And that's something that I've stood against personally most of my life, is you have to give the process and the rights of the people the time to play itself out before people make comments that are, when they don't have the full facts. And I'm not talking about you now. Believe me, I'm not. You have to wait until and then you can make your comments. Your comments, once the process is over, are your rights under the law. And if you feel as a council person that there's been a breach of trust by your former police chief, now I'm talking about you guys, well, that's your ability to comment on it.
But I'm hearing everything about someone in that position as an individual, and less about their responsibilities as leader?
Well, you have to go through the 7 standards of just cause, though. You see, there was a decision made in this state a long time ago. Not that long ago, but a good number of years ago, that the rights of those people are to be protected and are paramount. You know, we have a long history in this state of protecting, until recently when Act 10 came along, protecting, which didn't affect police and fire, protecting the rights of these municipal employees who have earned liberty and property interests by the status of their positions that they've entered into. And they are individuals. Their rights need to be protected as individuals. And that commission, when they're police and fire people, is the one who determines violations of rules by them. It's not the council, it's not the mayors, it's not the legislature, it's not the governor, it's that commission. And of course, you know, if you've got someone who's bad in a position, who's a bad chief or a bad captain or somebody, that's a breach of trust. But that breach of trust, as far as the law in the state of Wisconsin has been established, that person deserves that procedural due process and the 4 corners of that process that we've talked about, above all else, until they've extinguished their rights of appeal. And you know, I've often said this, especially to juries, I'm sorry, but that's what the law is. And if you put yourself in that person's position, it looks a little different, because it's your rights that have been established, that people are commenting on, and people are making judgments on. That's not good. It's not good. I've sat with officers when they've gone through this, and it's horrible.
You spoke before about, I mean, you described it as the policy-making authority of the police chief. It sounded more operational from what you were describing, rather than a matter of kind of written policies and procedures.
No, it's both. No. It's both. It's written policies, and it's called a custom.
But the sets of concerns that I'm speaking about have exactly to do with what that leader's entrusted with, right? So you won't be surprised for me to kind of bring this perspective that says, meanwhile, they are in charge of this force of people. And I hear what you're saying about that person's rights, but meanwhile, you know, they're in that leadership position, and by virtue of their authority, you know, affecting that work environment for everybody else.
Well, but that's why you allow suspension with pay in the statutory scheme. You get them out of the way until there's a determination as to what has happened. Were there rule violations? Were there policy violations? You put them off, and that was the whole point of suspension with pay, was to make sure that that person was out of the situation that they were involved in. And especially with a chief, if you've got a chief in that position, the removal of the chief from that position through a process of suspension with pay is a real strong indicator to the public, is it not, that that person has been removed, that person has rights, but they've been removed until it's adjudicated. And I think that really should be as far as we go, and in taking away in dealing with the public trust issue at that stage of the operation. at that stage of the due process. Now, as I understand it, your chief resigned. Is that correct? Under
That is correct.
discipline of some sort. I don't honestly know the discipline. I don't want to know the discipline. It doesn't matter to me from this perspective. But when I've often found in the last 40 years that that's a hell of a statement, isn't it? That someone resigns or retires rather than faces the potential discipline that would be meted out. They're removed from the violation of the public trust. They're gone, they're out of it. And they've gone through a process that has provided them with their rights. And it's probably a pretty good result, from what I know, of your situation in your city. Gone. I don't know what more we can ask. The process worked. I think it worked very well. And I think your commission did their job. Whether their job was done perfectly, I don't know. Was it done with some error, or was it done with good judgment? I don't know. All I know is it resulted in what I understand. You're saying a person who violated the public trust no longer being there. No longer can he violate the public trust. I hope that helps answer your question. That's just from my perspective, sir. And my perspective sometimes is a little bit different than
Thanks.
others.
Thank you, David.
That was a very good question.
Thank you, David. Are there other questions? I know some of us have 6 o'clock commitments, but if there are other quick questions, this certainly be an opportunity.
I have a question. Hi, I'm Alder Zarazua. I just thank you so much for all the information you provided. I am one of the newer alders, so I do appreciate everything you shared. So I guess a question I have that is related to all the things we've dealt with as a council and as a city. So after a resignation, is there still an appeals process?
No.
Or it's done?
Done.
Okay. And then, so I guess then after a case is done, what would be the norm for releasing records that would be under open records law related to that case?
I know that your city attorney is on the line and can probably tell you about open records documents which are protected. I always deal with them very specifically. When there's an open records request, I go to the statute. I go to the cases and I read it. And I'm not comfortable with making a very general statement as to what records of I think you're talking about the commission, is that correct?
Right.
Okay. What records are actually discoverable, because there's a whole body of law on that. And I usually don't get involved in that, because that's pretty much left up to the city attorneys or those lawyers that have been specially appointed to represent the commissions. That's a very good question. I just don't feel comfortable answering it. I wish I knew all the answers, but I don't.
That's okay. Thank you so much.
Okay, are there other questions? We appreciate all of the alders who took time to listen to Attorney Gregg here this evening. Lots of you all have the PDF on his presentation that will guide you into the statutory areas that I think will be beneficial to take some time, study them, become familiar with them. I have asked John Quirk, Sarah, who's ever recording this, to please distribute electronic copies of this to the city clerk and to the Police and Fire Commission's administrator, Leanne Spoon. They'll be available to you to view, refresher course, or to the alders who were not able to be here this evening because of other commitments. But we want to make sure that that's available for you to have an opportunity to refer to. Clearly, all of us who serve this community as either elected or citizen commissioners we have an obligation to know and to follow the laws and statutes that outline our roles and responsibilities. And you all deserve a lot of credit for taking a couple hours here on a busy Tuesday afternoon to listen to one of the best in municipal law, to continue that journey of learning, to know that we are all governed by a myriad of laws and rules and statutes. And we certainly appreciate that. So with that, I will adjourn. Commissioner Ostrowski, were you trying to get my attention? No? Okay. With that, I will move adjournment of the Police and Fire Commission at 5:54. Is there a second?
Hirschling, second.
All in favor, please say aye. Aye.
Aye.
Commissioners, and Greg, a special thanks to you for taking time and always being there to answer our questions and to provide guidance. As always, it's very informative. And
All right.
thank you. Thank you, sir.
Thank you. It's been a pleasure. Thank you all.
Videos of these meetings are available for viewing on the city's website, stevenspoint.com/videos.